Do I have the right to privacy on my work computer? When we sit down at a work computer, open email, or even browse the internet during lunch, a question lingers. Do we have the right to privacy? Can our employer read our messages, check our browsing history, or even track every keystroke? The truth may surprise you. Under U.S. law, employers have broad power to monitor activity on company-owned devices, but there are limits. Privacy depends on federal law, state rules, company policies, and whether workers have a reasonable expectation of privacy. In this video, we'll break it all down. We'll cover what federal law says, how state laws differ, what courts have decided about workplace monitoring, and practical steps to protect ourselves. By the end, we'll know exactly where our digital privacy begins and ends at work, and why hitting send on a work computer is rarely as private as we think. 1. Federal law and the ECPA. At the federal level, the main statute is the Electronic Communications Privacy Act, ECPA, of 1986, which includes the Stored Communications Act. These laws generally prohibit intercepting electronic communications without consent. But the law also makes exceptions. The ECPA allows employers to monitor communications on systems they own if there is a legitimate business purpose or if one party consents. Courts have broadly interpreted this to mean employers can review emails, track internet activity, and use monitoring software on company computers. Example: an employee uses their company email account to send personal messages. Because those emails travel through company servers, courts have held the employer may legally review them. The Stored Communications Act adds some protection. Employers cannot break into private, password-protected accounts like personal Gmail if stored on third-party servers. But if we access Gmail on a work computer, activity logs and even cached data might still be visible to IT. So under federal law, workers should assume if it's on a company device or network, it's probably subject to monitoring. 2. The reasonable expectation of privacy. Courts often use the idea of a reasonable expectation of privacy to decide cases. If a worker could reasonably expect privacy, monitoring may be unlawful. If not, employers usually win. Key factors courts consider: company policies. If the handbook or login screen says all activity may be monitored, privacy expectations are weaker. Ownership of equipment. Work computers are employer property. Personal devices generally carry more privacy. Purpose of monitoring. If tied to business needs, courts are more likely to uphold it. Notice. Workers given advance notice usually cannot claim surprise. Example: a New Jersey case found that emails sent from a personal Yahoo account on a work computer were protected because the employer never warned workers of monitoring. By contrast, in other cases where clear policies existed, courts allowed employers to read emails. 3. State laws on workplace privacy. Federal law sets a baseline, but states add important differences. California recognizes a constitutional right to privacy, even in private employment. Employers must balance monitoring with worker privacy. Connecticut and Delaware require employers to notify workers if they electronically monitor activity. New York passed a law in 2022 requiring written notice and acknowledgement from employees before monitoring emails or internet use. Illinois has the Biometric Information Privacy Act, restricting collection of fingerprints, facial scans, or similar data without consent. These laws show that privacy protections vary widely by state. A worker in Texas may have little protection, while a worker in California or New York may have strong arguments if monitoring is excessive or undisclosed. Example: a California court blocked an employer from secretly recording keystrokes because it was overly invasive compared to the business need. 4. Employer monitoring in practice. What does monitoring look like in real workplaces? Employers may use email monitoring, reviewing sent and received messages, web tracking, logging websites visited or blocking certain content, keystroke logging, tracking every key pressed, sometimes even passwords. Screen capture software, taking periodic screenshots of activity. Remote access. IT departments can often see active sessions in real time. Employers justify this by citing productivity, security, and protection against harassment or data leaks. But problems arise when monitoring crosses into private life. Example: during the pandemic, remote workers reported invasive surveillance software that recorded webcam images or tracked typing rhythm. Critics argue this violates privacy and morale. Courts have generally upheld monitoring tied to business reasons, but overly intrusive surveillance, especially outside work hours, may violate privacy rights. 5. Real cases that shaped the law case. 1. Smith v. Pillsbury, 1996. A worker was fired for sending inappropriate emails on a company account. He argued privacy. The court disagreed, ruling that company email is not private if policies allow review. Case 2. Stengart v. Loving Care Agency, 2010. In New Jersey, a worker accessed her personal Yahoo Mail on a work laptop to email her attorney. The court ruled those emails were protected by attorney-client privilege, even though the employer owned the laptop. Case 3. New York Monitoring Law, 2022. Employers must now notify workers in writing about monitoring. Failure to do so can lead to penalties. These cases illustrate the balance. Workers usually lose if they rely on company systems for personal use, but sensitive categories like attorney-client privilege or states with stronger protections can swing outcomes. 6. Worker rights and best practices. What should workers do if they care about privacy? Assume no privacy on work devices. Treat work computers and email accounts as business only. And read company policies. Know if monitoring is disclosed. If not, state law may give leverage. Use personal devices for personal matters. Access personal email or banking only on your own phone or computer. Be cautious with remote work tools. Video calls and collaboration apps may be recorded. No special protections. Attorney-client emails, medical information, HIPAA, and union organizing activity may carry legal protections. Example: a worker in California avoids sending personal messages through company email. Instead, they use their personal phone on cellular data. When a dispute arises, the employer cannot touch those personal messages, but can freely review the work email account. 7. The bigger picture: technology is advancing fast. Employers now use AI tools that analyze productivity, location, and even mood from digital activity. Remote monitoring exploded during the pandemic. At the same time, workers are pushing back and states are passing new privacy laws. The law still leans heavily in favor of employers. Courts generally say, if it's on a work computer, workers should not expect privacy. But the tide may shift as surveillance grows more intrusive. For now, the safest rule is simple. If it's on a work system, assume it can be monitored. Protect personal life by keeping it off company devices. So, do we have the right to privacy on our work computer? The honest answer is, not much. Under the Electronic Communications Privacy Act, employers can monitor emails and activity on company systems for business reasons. Most courts side with employers if they own the equipment and gave notice. But there are limits. State laws in places like California, New York, and Connecticut give stronger protections. Personal accounts accessed on personal devices are usually private, and special categories like attorney-client emails remain protected. The takeaway: use work computers for work, and keep personal matters personal. If this video helped, share it with coworkers, because knowing the boundaries of privacy keeps us all safer and smarter at work.